All right, let's kick things off with a bit of a legal riddle. What happens when the government passes a law, but it's so unclear, so badly written, that literally no one, not you, not me, not even the police, can figure out what it actually forbids? So when is a law not really a law at all?
I mean, think about it for a second. Could you get arrested for just wandering around? Or strolling? Or for being a habitual loafer? It sounds absolutely ridiculous today, right? But for a long, long time in America, you absolutely could be. And believe it or not, that's where our story starts.
You know, these aren't just some funny, old-timey words from a history book. This was the actual text of a city law in Jacksonville, Florida, all the way up until 1972. Laws like this, these so-called vagrancy laws, were used for decades to control anyone the authorities deemed undesirable. And this specific, super archaic language, well, it set the stage for a major showdown at the Supreme Court.
So all of this leads us to a landmark case that really put these bizarre laws under the microscope. Papachristou versus City of Jacksonville. And it's a story about a group of just, ordinary people who found themselves on the wrong side of an extraordinarily unclear law.
So get this picture in your head. It's Jacksonville. 2 white women and 2 black men are just driving home after grabbing a bite to eat. And this group, it included a teacher, a Vietnam vet, a college student, and a warehouse worker. Suddenly, police pulled them over and arrested them for, get this, prowling by auto. There was zero evidence they'd done anything wrong. Their only crime was being out and about in a way that some officers found suspicious under that ridiculously vague law. It's a classic example of how these laws just open the door for discriminatory enforcement.
So how in the world do you fight a law that makes driving home with friends a potential crime? Well, the answer lies in this really powerful constitutional idea that was designed to solve this exact riddle, the void for vagueness doctrine.
Okay, so what is this doctrine? It's rooted in the idea of due process, which is fundamental to our legal system. Basically, it says that for a law to be legit, it has to be written clearly enough that a regular person, an ordinary person, can read it and know what's legal and what's not. If a law is so fuzzy that, as the courts say, men of common intelligence must necessarily guess at its meaning, then it's just not a fair law.
So the doctrine really stands on 2 main pillars. First, there's fair notice. You have a right to know what the rules of the game are before you can get in trouble for breaking them. Simple enough, right? But the second pillar is what the Supreme Court calls the more important aspect, and that's preventing arbitrary enforcement. See, a vague law doesn't just confuse us. It gives law enforcement a blank check to make up the rules as they go, based on their own biases and whims.
Now, this whole idea wasn't just invented for the Papachristou case. It actually has a long and pretty fascinating history, and its focus has shifted, really shifted over time.
If you look at this timeline, you can really see how the doctrine has evolved. It first pops up way back in 1914. Then, during what's known as the Lochner era, it was mostly used to strike down economic rules, things like price controls. The huge pivot point was 1972 with Papachristou, which put the focus squarely on protecting our individual freedoms. And it's still incredibly relevant today, like in the 2015 Johnson case, which threw out a vague federal sentencing law.
So, what does this vagueness actually look like in the real world? It's not always as obvious as banning rogues and vagabonds. The Congressional Research Service actually looks at this and has pointed out some common red flags in laws that get tossed out for being too vague.
Here are some great real-world examples of phrases that courts have said are just too vague. What in the world is credible and reliable identification? Who decides that? Or how about a law against being annoying to persons passing by? Annoying to who? What's the standard? What's the difference between a group of friends hanging out and a gang? You see, every one of these phrases fails that 2-pillar test. They don't give you fair notice, and more importantly, they give law enforcement what the courts call a standardless sweep to do whatever they want.
Okay, so you might be thinking this whole doctrine is just a settled, common-sense part of our legal system, but it's not. Actually, in recent years, it's come under some really sharp criticism from inside the Supreme Court itself, sparking this fierce debate about whether it's even legitimate. And Justice Clarence Thomas really gets to the core of this debate in this quote here. He argues that, hey, you can't actually find the vagueness doctrine in the original text of the Constitution. He sees it as something judges made up, and he says it has an uncomfortably similar history to another controversial idea, substantive due process. So this is the heart of the whole controversy. Critics, like Justice Thomas, think the doctrine is basically a tool that lets judges act like lawmakers, striking down laws they just personally don't like. It's a huge philosophical clash, really, between those who think judges should be very restrained and defer to legislatures, and those who think courts have a duty to step in and protect our rights from government overreach.
So, with all this debate swirling around, why does this doctrine still matter so much? Well, it all comes down to one of the most basic principles of a free society, the huge difference between a government of laws and a government of men. Ultimately, the void for vagueness doctrine is a firewall. It's a fundamental check on government power. It makes sure that the rules of the game are written down for all of us to see and understand. It stops the law from becoming a weapon that can just be used however those in power see fit. Without it, the line between what's perfectly legal and what's a crime could be decided right there on the spot by a single police officer's whim. And all of this leaves us with one last big question. We know laws can't be perfect. They can't have mathematical certainty. Lawmakers have to use words, and words can be fuzzy. So, where do we draw the line? How clear does a law really have to be fair?
This is for entertainment and educational purposes only. This is not legal advice.